about best reading his shirt lift.
Why wouldn't that be a basis for sending it back to consider these arguments in the first instance? If you aren't prepared to defend the due process argument and perhaps your frontline argument on that things that happen before employment are categorically and always off the table. If those two decisions, which, to be fair, were of course issued under a time constraint, might have some flaws, why shouldn't it go back to reconsider it? You've advanced a lot of new arguments here, so have your friends on the other side.
So it should go back. It should just not go back with an emergency stay being granted, which is an extraordinary relief that depends on my friends on the other side showing an extraordinary burden of irreparable harm and showing that they have a likelihood of success on the merits. And I think likelihood of success on the merits in this context doesn't mean just a likelihood of showing that the two grounds that were seized on in the quick briefing below are wrong, but that they're actually right. And I think the briefing here has done two things. I think it showed that we're right. I'm not abandoning my frontline arguments, but I love my backup arguments. I think they are very strong. And I think it shows the sort of, the problems that happen when you try to decide some of the most important issues of constitutional law in this kind of rushed way.
Can I ask you about the mandamus question? Why isn't mandamus the appropriate avenue here?
It is an appropriate avenue at the end of the case. Even at the end of the case, though, I think, and this is consistent with what Professor Bray says in his article, even at the end of the case, I don't think you have to leap to mandamus. I think you can have a declaratory judgment
Well,
first.
Let's put the declaratory judgment issue aside, because we can talk about mandamus for a second. Assuming there is such thing as a preliminary injunctive relief for mandamus, which I'm going to ask you if that's a thing, first of all. And second, if it were, wouldn't the standard that you'd have to show likelihood of success be the likelihood of success under the mandamus standard?
So a couple of things. I mean, I don't like hearing preliminary mandamus any more than Judge Friendly did.
No.
I don't think it's the right way to think about it. I think it's preliminary relief to preserve the status quo, or if you want to be more specific, preliminary relief to preserve a de facto officer in their office while the case proceeds. And that is a relief.
Why isn't that preliminary injunction or mandamus? I know what those two buckets are. I'm not sure I'm familiar with the third one you're describing.
What I'm describing is a preliminary injunction. I'm just saying it's not a preliminary mandamus. It's
wouldn't it have to be, though? If your cause of action were mandamus, and let's just suppose that's what it is, it would be preliminary injunctive relief because you have likelihood of succeeding under the mandamus standard, I would have thought.
Well, perhaps. I mean, two things about that. One is, I'm not sure in this kind of mandamus posture, I don't think I agree with General Sauer that the standard is the standard you would have in like a Cheney situation. I do think this kind of original mandamus as the remedy in this particular situation, I would resist the idea that that's sort of the standard, more appellate mandamus standard. That's a debate, even with all the briefing we've had, we haven't had a good chance to really duke it out on that. But I would say that's part of the reason I resisted the idea that you have to go to mandamus, because I do think you would have declaratory judgment. I do think declaratory judgment.
I asked you to put that aside for the moment.
No, and I tried to, as long as I could.
All right.
But
then I give up. Okay.
Then to answer your question, I really had to get to declaratory judgment. I would like to say this is an issue the D.C. Circuit has thought a lot about. And there's a particular case worth reading, the Swan against Clinton case. And that's a case where they kind of wrestled with this question about, would you have mandamus against the president at the end of the day? Can you direct the president? And there's a great concurring opinion by Judge Silberman where he basically says, look, the judiciary is creative and clever enough to figure out a way to fashion injunctive relief against the lower federal officials. And that solves the problem about having the relief run against the president. And the reason that the D.C. Circuit has wrestled with that in a couple of contexts, and I think the Chief Justice alluded to this, if they were really right about that, then you'd have to wrestle with this at the beginning of the case as to whether there's any redressability at the end of the case. And in the Swan case and even in the Severino case, the D.C. Circuit has said there's not a redressability problem. We can figure out a way to direct the relief at the lower government officials, and that will be sufficient under the day.